Hello everyone and welcome to a bit of a special edition video from the Legal Studies guy. Releasing this on Melbourne Cup Day, so 2021, so we're 8 days out from this year's Legal Studies exam, so right in the thick of exam preparation, and we're going to go through today a bit of a video on some of the common misconceptions that come up across different points of the study design. So I've just picked out a bunch of these and I'm just going to work through from the start of area 3.1 through to 4.2 and some of the things that tend to come up in answers that we want to avoid. Being 8 days out from the exam, a bit of a I suppose shameless plug. It's now that really in terms of preparation you should be digging into practice exams and trying to really put yourself into those same conditions as you'll be under in the exam next week. And we do on our website have a few practice exams for sale. So some fresh ones this year. You can buy some old ones we've got as well as part of bundle packs. And we've also got last year's for sale at a heavily discounted price just because last year's study design had a few things cut out around high court cases. So you can get some of those as well. So the link will just be down in the bio or in the description there if you wanted to jump on and have a look at what we've got. But without further ado, we'll jump into some of the common mistakes that come up on some of the content in legal studies. So we're going to start here in area 3.1, particularly 3.1.4, which is the rights of victims. And we know that the study design stipulates 3 specific rights that you need to know: giving evidence as a vulnerable witness, the right to be informed of proceedings, and to know the likely release date of the accused. Past exam questions about rights of the victim have also accepted the ability to give a victim impact statement as a right of a victim as well. So you can use any of those. But I really want to dig into this idea of what is a vulnerable witness, because there is this misconception that tends to come through, which is that every witness can access vulnerable provisions, and I assume most of you have focused on this idea of alternative arrangements. So if you are a vulnerable witness, you can give evidence in an alternative way, and this is usually from a different room using CCTV, so closed circuit television, or if you are in the courtroom, perhaps having a screen in front of you or a support person. And again, as I said, the misconception is that this is available for anyone in any case. You can just basically be like, yep, I'm vulnerable, let me go and give evidence from a different room. The reality is these alternative arrangements are only available in these types of cases, and particularly the first two are the ones that are most prevalent. So sexual offence cases and family violence cases. And even then, you still have to more or less do an application for it. Now, the court can just say, yep, you get to do it like this. But generally speaking, you actually have to ask for the arrangements. Say you're any witness in a sexual offence case, you would have to say to the court and more or less apply through the prosecution and say, hey, I'd really prefer to give evidence through an alternative arrangement rather than being in the courtroom with the accused person. The exception to that is if you are the complainant in a sexual offence matter, which means you are the victim, that means you get this automatically. So obviously we are focusing on this idea of your right as a victim, which means focusing on the idea that if it's a sexual offence matter, you get to give your evidence through an alternative arrangement automatically. Sorry for those warnings, I don't know what's going on there. But any other matter, family violence, you have to ask for it. Any other matter, these arrangements aren't available to you. So understanding there's a bit more nuance than just being like, yep, victim, I get to go and give evidence through CCTV. So one that might come up, for example, is if you're the victim in an assault matter, maybe that's the case study, you wouldn't, unless it's family violence related, you wouldn't actually have access to these alternative arrangements unless there's further provisions that apply to people under the age of 18 or with a cognitive impairment. So really important to understand that as a victim, you only get alternative arrangements in special circumstances or specific circumstances that are listed there. Legal aid. This one's one that comes up quite often. So with legal aid, we need to understand how institutions like legal aid and community legal centres assist an accused person. So the focus there on someone who is charged with an offence. And I think one thing that comes through often as a misconception is this idea that Victoria Legal Aid has like a bank of lawyers. So like they've just got a bunch of lawyers in a vault somewhere, and basically you get legal aid, they get one of these lawyers and they give them to you. And I feel like this maybe comes from watching too many American TV shows where they talk about, your right to a lawyer. If you can't afford one, it'll be provided for you. And we get this kind of perception that, that's what legal aid does. It gets lawyers and it gives them to you. The reality is quite different. Realistically, or really what happens is, if you want legal aid support because you can't afford a lawyer yourself, you complete an application to legal aid. And if your application is successful, legal aid will give you a grant, or in simple terms, a sum of money that you will then pay a private lawyer. So that's essentially how it works. VLA does have a Victoria Legal Aid Chambers where they basically have some public defenders who will work in really high profile matters. A guy you can look up who used to be their senior counsel is Tim Marsh, and he is prominent. You'll find news articles on him because he's represented some people who've been charged with very serious crimes who have had high levels of disadvantage, which certainly don't make up or make their crimes appropriate in any way, shape or form, but it means they also wouldn't be able to access and have fair access to the system without legal support. And Tim Marsh has represented some of those people. So he was senior counsel for VLA, but generally speaking, in practice, you have to apply to VLA to pay a private lawyer. And how that really works out in the real world is essentially most people won't ever actually go to VLA themselves. They might, ring them up for some advice, but you'll actually go to a lawyer and the lawyer will help you fill out the application. And maybe that could be a community legal centre. They might help you apply to VLA. But a lawyer will actually complete this application to VLA for you, and then VLA will pay them. So I know there's for example, in Horsham, where I'm based, there is a lawyer here who basically a lot of his work, his clients come in, he helps them fill out the legal aid paperwork, and then legal aid pays him to support them throughout their criminal proceedings if they've been charged with something. Outside of this, one of the other things to understand about VLA is that they do supply duty lawyers. So they go to court for the day and help people who appear in court in that day. Again, these are usually private lawyers who are subcontracted to be a duty lawyer for a day, not, again, someone employed exclusively by legal aid. So it's important to understand, again, that legal aid's kind of there as a coordinating body. They have access to money that you can apply for, but then that money goes to private lawyers to do their work for them. There's a little bit of further info there about how duty lawyers work, which might help you, because again, not everyone who rocks up to court can have the duty lawyer just represent them. Generally speaking, they can only provide information, not even advice, unless you meet an income test. So important stuff there. Legal aid doesn't just have a body of lawyers that they hand out to people. They're more a coordinator with a fund of money that they can give you to pay for a lawyer. Mitigating and aggravating factors. This one comes up just because a lot of kids have a really simplistic understanding of how they work. And the simplistic misconception here is that mitigating factors decrease your sentence and aggravating factors increase your sentence. Now, ultimately, mitigating factors and aggravating factors will lead you to getting a lower or a higher sentence. But as I said, it's an overly simplistic understanding of how they work. And this is actually taken from the Sentencing Council of Victoria's website. And I'll start down at this bottom point here. And it says really clearly, aggravating factors increase the seriousness of the offence or the offender's culpability. Mitigating factors reduce the seriousness of the offence or the offender's culpability. And through these things, that will therefore lead to an increase or a decrease in sentence. But the mitigating and aggravating factors themselves don't adjust the sentence up or down. Why that's overly simplistic is it kind of paints a picture, if you just say it increases and decreases sentence, you're kind of painting a picture of a judge sitting there doing a sentence and being like, great, I'm going to send this person to jail for 4 years. Oh, wait, there's an aggravating factor, 4 years, 3 months. Oh, but now there's a mitigating factor, 4 years, 2 months. Oh, another mitigating, 3 years, 9 months. When sentencing doesn't work that way. And if we look again at the Sentencing Council of Victoria's information about this, you'll see factors that need to be taken into account when sentencing an adult. And if we look at the number of things the judge needs to consider here, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. So the judge is considering this really wide range of things, including aggravating and mitigating factors, but also things like the maximum penalty for the offence, what a standard sentence is if there is one, current sentencing practices, so that will include looking at cases that are similar, whether the crime is motivated by hatred or prejudice, all of these things kind of into a big cauldron, and then based on everything, considering everything, this is why a judge is so... I suppose, or why sentencing is so fair and judges are so experienced with it, is that once they consider all of these things, this big melting pot of different considerations, they from there decide what is the right sentence for that person in those circumstances. And it's not as simple as just being like there's a number and an aggravating factor makes it higher and a mitigating factor makes it lower. It's much more complex and nuanced. And that's why it's important to say with aggravating and mitigating factors that they increase or decrease culpability or seriousness of offence rather than saying they increase or decrease sentence. So an important one to be on top of. Just on that as well, kind of mitigating aggravating factors again, but also guilty pleas. And I just bring this one up because it was in a practice exam as a solution from a company. And if you'd seen this, you might develop this misconception when it's actually wrong. And this is the idea that pleading not guilty, so a not guilty plea, so going to trial, is an aggravating factor. And it's not. What I think, or where the confusion comes from, is we know that if you plead guilty, a guilty plea is a more or less a mitigating factor. It shows remorse, it shows you're taking responsibility for your actions, plus you're saving the court's time, and as a result, you're eligible for a discount. And this is actually included in the Sentencing Act. It's like, hey, if you plead guilty, you will get a discount. So naturally, our brain just goes to, well, if we're getting a discount for pleading guilty, it must be an aggravating factor to plead not guilty because we're not getting a discount, so our sentence is going to be worse. The reality is, yes, our sentence will be worse if we plead not guilty. So you will get a more severe sanction for pleading not guilty if you're subsequently convicted. But it is not an aggravating factor. And it's important to understand this because by pleading not guilty and going to trial, you're actually exercising your right to a fair trial. You have the right to a trial if you want it. And you have the right to a trial because you're presumed innocent until proven at trial. So if you choose to go through that process, if you choose to have a trial and exercise your presumption of innocence, you can't be punished for that. Yes, you're going to end up with a worse sentence than if you'd gone with a guilty plea and got a discount, but pleading not guilty, exercising your right to a trial, is not aggravating. And that's an important thing to understand. VCAT. Now, this one comes up all the time, and there's a few to sort of work through, and we'll work through mediation as well as we get into civil law here. How does VCAT resolve disputes? And basically the misconception that tends to come through is that VCAT resolves disputes using ADR methods and courts resolve disputes using trials. And that's it. There's like this clear distinction. You go to court if you want a trial and a trial only. You go to VCAT if you want some kind of ADR. The reality is not that straightforward. VCAT is a great dispute resolution body because they use a variety of different resolution methods. They actually look at the circumstances of the matter and they decide what's going to be the best method at their disposal to resolve it. And the most common ones they use are mediation, naturally, and courts use this a lot as well, which we'll talk about. Compulsory conferences, which are effectively conciliation, and that's where they'll book those in for maybe half a day, and you go in with the VCAT member, and you basically talk through, and the VCAT member can have private one-on-ones with the parties and actually start giving them suggestions on, hey, issues that could be resolved or where they could go with the dispute. Fast-track mediation and hearing is available for small claims. This is the idea that you can basically sign up to fast-track mediation and hearing. You rock up to VCAT for one day, you do mediation in the morning, you hopefully resolve the dispute. If you don't resolve the dispute, you have your hearing in the afternoon, and it's done. So the dispute is resolved that day. There's no like failed mediation, come back in a week or come back in a month. So they use fast-track mediation and hearing, which is a combination of two methods. Or ultimately, VCAT is able to hold hearings where they hand down a legally binding order at the end of them. And it's important to note that these VCAT hearings are not arbitration. So arbitration is a different thing that you sign up for, and you usually go get an arbitrator from like a private company like the Melbourne Arbitration Centre. A VCAT hearing is kind of its own special, it's not quite a trial, but it's not arbitration. It's its own special type of dispute resolution method that VCAT utilises, and that's where the member hears both parties. There are some rules around how that works, not as stringent as a trial, obviously, and then the VCAT member makes a decision. So VCAT's great because you can basically work through these methods and get the dispute resolution approach that works best for your circumstances, and it is not just all ADR methods. And likewise, the courts aren't just all trial. So really common misconception, understanding that VCAT is a lot more nuanced than it first seems. And this brings us into the use of mediation. And this one comes up so often. And this is like 3 misconceptions here that I want to draw on and make sure that you're across. The first one is that mediation is only used for minor disputes. And this is so often like, hey, this dispute looks really complex. Well, mediation's not appropriate because it's complex. The reality is mediation is used for really complex disputes all the time. The courts use it all the time. In fact, basically, like the Supreme Court's done trials and things where every matter that comes before the Supreme Court will be sent to some kind of judge-led mediation to try and get a resolution before going to trial. Because courts know that, going to trial is really costly and takes a long time. It limits the other work that they can do. And if they can get the dispute resolved in another method before that and clear it from the court system quicker, why wouldn't they? And we know that I think mediation in the courts, like somewhere between sort of 40 and 60% successful. And if you talk to a Supreme Court judge, they'll actually say that they might send a matter to mediation up to 3 times before trial, because they actually know that even if mediation doesn't resolve the dispute, it can help make the dispute less complex because parties might agree on some aspects of the dispute. So a Supreme Court judge might, when a dispute's filed with the Supreme Court, might immediately send it to mediation, hoping that the parties will agree on some things and the dispute all of a sudden becomes a little bit smaller. Once parties have been exchanging pleadings, for example, going through a discovery process, sharing the evidence back and forth as their arguments become more developed, the judge might be like, you know what, it's worth sending them to mediation again, because now that they're more settled in their positions, they might be more able to come to a resolution together. And often, maybe for a 3rd time, a judge will send parties to mediation just before trial, because they know that just before trial is when both parties are absolutely locked in with their arguments, their evidence, and maybe one party realises that the trial might not go as well for them. So they know that mediation can get a resolution that is a little bit more in their favour than if they go to trial and it's just win-lose. So it's really important to know that really complex disputes are great for mediation as well, not just minor matters. And this sort of then feeds into this second misconception that mediation doesn't need legal representation, and this comes with the idea that mediation is cheap. So mediation doesn't need lawyers. Well, if it's a really minor matter where you're having a fence dispute with a neighbour, you might not need legal representation or you wouldn't use legal representation if you go through the Dispute Settlement Centre of Victoria. But these really complex matters in the Supreme Court that are using mediation, absolutely both parties have lawyers. There are lawyers out there who are like, hey, we are lawyers who specialise in mediation. Get us to come in for your mediation. We'll help you win your mediation. So mediation, or the use of a legal representative in mediation, depends on the nature or the issue at hand. It depends on the nature of the dispute. And if it's a really complex matter that you're going to have lawyers for anyway, you're going to have lawyers in mediation. Why mediation ends up being cheaper though is because if you can just resolve the dispute in mediation and you don't need to then go on and have a trial or some other method, you then don't have to pay lawyers for the rest of that dispute resolution. So that's where the cost comes down, even though you might need to use lawyers in mediation. Finally, mediation isn't legally binding. Now, this is a misconception because the reality is, like any agreement between two people, mediation isn't binding. You kind of got two parties just being like, hey, I'll do this, you do this. Yeah, sweet, let's go off and do it then. But because parties know and because lawyers are often involved, they know there's a risk of one party not following through on any agreement. Parties actually finish mediation these days by signing a contract. And this is called usually a deed of settlement or terms of settlement, where they basically sign it off and say, you're going to do this and I'm going to do this. And this is really, really important because that is a contract that is enforceable. So if one party doesn't comply, you can actually have that contract enforced through the courts. Yes, you are going to have to go to court to get the contract enforced. Yes, it is going to add more cost in terms of using lawyers to do that, etc. But the reality is mediation is usually binding because parties will sign a contract that makes it so. So really important to not just say mediation's not binding. We've got Roach next, heading into 4.1 now. There's not as many misconceptions in 4.1 and 4.2, so we can whip through them pretty quickly. So Roach is, and not everyone would have learnt Roach, so this is that dot point, one High Court case interpreting sections 7 and 24 of the Australian Constitution. Roach is easily the most common case taught for this dot point. It's the one that's in our videos. And the misconception that comes through is that the High Court found an implied right to vote in Roach. So the decision of the High Court created an implied right to vote, which means you all get to vote and the government can't take that away. The reality is that didn't happen. The Roach case actually found that the government can remove your ability to vote if they have a substantial reason. So for example, if you've been to prison for 3 years or longer, can't vote. It's considered a substantial reason to take away your ability to vote. So you do not have a right to vote. Where the confusion comes from is that one High Court justice, just one, so there's 7 on the High Court that all give their decisions. Some of them write their decisions together, some of them write them separately. There was one High Court justice, I think they were actually the Chief Justice at the time, and in their decision, they said that they thought there was an implied right to vote. And they wanted there to be, they said, yeah, it's an implied right to vote. But none of the other 6 did, which means there is no implied right to vote as found by the High Court. And you can't say that there is one. So it's very important to understand that Roach upholds representative democracy. Most of the population have to vote because it says in section 7 and 24 that people or politicians are chosen directly by the people, but you don't have the right to vote. Important to not say that because it is just wrong. And this is our final one, not as common, but have seen it come through a few times around how the VLRC and particularly Royal Commissions work. And just to it depends on the Royal Commission you look at. I know our videos look at the Child Abuse Royal Commission, but a lot of schools use Royal Commissions that are Victorian based. A great one recently with the Royal Commission into Crown and its failings as an organisation. But if you've looked at a national Royal Commission, the thing that can come through is this idea that Royal Commissions are national and then the VLRC is Victorian. The reality is Royal Commissions can be called at a Victorian level, so the Victorian government, or technically the governor, on the advice of the government, can call for a Royal Commission that's just based in Victoria. So recent just Victorian ones are like the Royal Commission into the use of Lawyer X, and as I said, the Royal Commission into Crown. Or they can be at a national level called by the federal government. And basically, it's just down to really division of powers kind of stuff. The state government would call a Royal Commission into things they're responsible for. The federal government would call a Royal Commission into things that they're responsible. So recent federal Royal Commissions are veteran suicides, been called recently. They also had a Royal Commission into the aged care sector and the issues with that. And obviously child abuse is one that we've looked at in our videos. Whereas the VLRC, just Victorian legislation. It's a Victorian Law Reform Commission. It's set up by the Victorian Parliament, and therefore the Victorian Attorney General, who's a member of government and Parliament, will ask them to investigate a law reform issue relevant to Victoria. Like, for example, committals, which is one that they've looked at recently, so the Victorian criminal justice system. They are some common misconceptions that tend to come up often in answers. Some of the big ones there, particularly around mediation and VCAT, and understanding the nuance of those is really, really important when you get questions on things like that, because often you are talking about their appropriateness and why they're good for a situation. As I said, 8 days out, even if it's a bit closer now when you're watching this, the key thing is get those practice questions done, be doing work that is relevant to the exam, not just reading over notes and things like that. And yeah, if you want to support the Legal Studies guys, as I said, check the link in the description to our online store that has some practice exams available. And most importantly, good luck.